All right. Well, hopefully this is all working and hopefully you can hear me. I'm not in my usual office, so I'm hoping that this still works. Welcome, everyone. My name is Lior Samfiru. As you know, I'm the employment lawyer. And why am I here? Well, just as always, I'm here to answer your questions. I'm here to talk to you about employment law. I'm here to educate you and inform you about your legal rights in the workplace. So if it has to do with your job security, with your severance, with the way you're treated, with your boss, then this is the right place to come and ask questions. Whatever the workplace employment issue is, there are answers, there are solutions. So again, welcome. My name is Lior Samfiru. I'm an employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. We're one of the biggest, if not the biggest, employee side law firm in Canada. And I said, I'm here every Wednesday answering your questions. And that's exactly what I want to do on this session. So don't be bashful. Ask those questions. Type it in. Press return. I'll see it. I'll answer it. And you can walk away with the knowledge that you need to have. Let me give you some other contact information as well. If you want to connect with me off air, if you want to reach out to me, not on Facebook, not on YouTube, you want to have a private chat with me or private email exchange, very, very easy to do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address right there. And you'll see all the contact information, phone number, email address. It's all there. It's all there for you to make sure that you can answer and see and connect with me. So that's the place you go to, employmentlawyer.ca. But that's, of course, after this session. Right now, on this session, at this time, I'm live. If you're in Alberta, if you're in Ontario, if you're in British Columbia, and if you have a workplace issue, man, have you found the right place? Take advantage of the opportunity. Have one of the top employment lawyers in the country here ready for you and answering questions. And I'll take those questions as soon as I get them. Now, in between your questions, let me start talking about a couple of things that I think you need to understand. So the general rule, of course, when it comes to losing your job is that your employer is allowed to let you go generally, pretty much for any reason, as long as severance is paid. So in most cases, an employer does not have to have a good reason or any reason to let you go, but they have to pay severance. The thing to remember, in the vast majority of cases, over 90% of the time, the severance that people are offered is a lot less, and I do mean a lot less, than what you're actually owed. And that's why it's so important to get that advice. Now, so in most cases, it's really about severance. But there are situations that, regardless of severance, it's illegal for your employer to let you go. So let me talk a bit about some situations where, regardless of the severance, your employer is not allowed to let you go. Now, I'm going to do this now, but I still want your questions. I'm live, you're watching me right now. Type in your questions so I can see them. And then, of course, I'll take those questions as soon as they get here. So the first thing I'll talk about before I take my first question is this. Your employer cannot let you go for discriminatory reasons, regardless of severance. So your employer cannot let you go because of your age or ethnicity or your gender, or if you have a disability. All that is discriminatory. In fact, that can't even form part of the decision-making to let you go. And if your employer were to do that, that becomes a human rights violation. It's illegal. Employer cannot do that irrespective of severance. Your employer can't choose to say, well, I want a younger person, so I'm going to let you go. Or you have these medical conditions, that's causing us a problem, so we're going to let you go. That is illegal. That's discriminatory. So if your employer ever does that, you're potentially entitled to human rights damages. You could potentially even get reinstated if you want that. So very important to remember, cannot be let go for discriminatory reasons, even if your employer pays you severance. Now, I said that, I'm live. My name is Lior Samfiru, of course. I'm going to start answering some questions right now. You got some time, you got an opportunity. Type in your question and let's get at it. So first question today, and thank you for that on YouTube, from Andy. How can you prove a wrongful dismissal? My sister-in-law is being told that she's being let go for workplace issues, but the claims are false. So ultimately, you don't have to prove anything. Her employer has to prove something. So in other words, if her employer is saying she did something wrong, their employer has to prove it. She doesn't have to prove anything. But keep in mind, at the end of the day, Andy, it may not matter, because her employer can let her go even if he doesn't have a good reason, but he has, or her employer has to pay her severance. And that severance can be as much as 2 years pay, 24 months pay. So the real focus is on severance. If she's paid proper severance, whether it's a good reason or bad reason, from a legal standpoint, won't matter. So the key here is have her give me a call. I want to understand why she's being let go, but I also want to understand, is she being offered severance? And if so, how much severance? I would bet you anything, without even speaking to her, that she's owed a lot more, and I do mean a lot more, than what she's been offered. That's assuming she was even offered anything. So Andy, best thing you can do for your sister is have her give me a call, connect with me. You see right below me the way she can connect with me, employmentlawyer.ca. Again, employmentlawyer.ca, the way to connect with me. Phone number is there, email address is there. So Andy, do the right thing. You took the first step. Second step is to get her to contact me. Okay? Thank you for that question, Andy, and you as well. If you're watching right now, hey, don't just watch, be a participant, type in your question, I'll see it, I'll answer it, and you can have that information to walk away with. As we're waiting for that next question, I was listing some situations where it's actually illegal to let you go. You know what, before I do that, let me take the next question from Videoland on YouTube. Can we be terminated while waiting for an arbitration hearing date in Ontario? It's over a vaccine policy. So if you're waiting for an arbitration hearing, Videoland, that means you're unionized. So only the union can help you. And it's important to remember, by the way, everything we talk about on these sessions, if you're watching me, everything I talk about only applies to non-union employees, does not apply to unionized employees. If you're unionized employees, your rights are in the collective agreement. Only the union can enforce those rights. So you'd have to ask your union the question. They are the only ones that can advise you, guide you, defend you, or pursue a matter for you. Okay? So only the union can answer that question. Next question on Facebook from Antonella. Can you help someone get back to work if they have put on a leave due to vaccine mandate, non-union, and doesn't work for hospital or long-term care? Yes. So if you're put on a long-term or if you've been put on an unpaid leave because of your vaccine status, you can treat that as a termination and either require your employer to pay you severance, Antonella, or potentially, yes, we can put pressure on your employer to take you back. Usually once they hear back from us, then they'll want to take you back. So you'll have those options. If you don't want to go back to work, but you want to be done with this employer, yes, we can get you severance. If you want to go back to work, then we can help you with that as well. But let's connect, okay? And for everyone out there, you should understand that in most cases, unless there's a government mandate that requires your employer to make you be vaccinated, unless that's the case, then if your employer has a vaccine policy and you lose your job because of your vaccine status, you're owed severance. You're absolutely owed severance because your employer is changing terms of employment. So very good question, Antonella, to reach out to me. I said that before, employmentlawyer.ca. Again, employmentlawyer.ca, and let's connect. Thank you for that. Next question on YouTube from JC2004. Why would an employer be legally required to pay anything more than minimum severance? Well, because that's the law. You asked me why the law would be the way it is. I don't know why the law is the way it is, except that is the law. The minimum severance is irrelevant. Every employee is entitled to much more than that unless they sign an agreement giving up their full severance. So minimum severance is irrelevant. The law has made it clear that every single employee has significantly greater entitlements than their minimum entitlements. And I'm not talking about, well, it's a bit more. I'm talking about your minimum entitlements can be 8 weeks severance. Your full entitlements, sometimes we call those common law entitlements, can be 24 months severance. Or your minimum entitlements could be 2 weeks. Your full entitlements could be 6 months. So that's why it's important to get advice. Why the law is the way it is, it's been that law for at least 150 years and potentially longer because we got our laws from England. So it's just the way the law always is, not controversial, and they absolutely have to. There's no choice, there's no option. It's not a nice thing. They are legally required to pay you your full severance. And that's why it's easy also to enforce it. So thank you for that question. Guys, you see how easy it is, right? You type your question, I read it, I answer it, and there you go. So take advantage. You got some time, ask your questions. And those joining us, of course, welcome. My name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. And what am I doing? I'm answering questions. All right, next question. I remember this name, Fortress Maximus. What a great name, on YouTube. My employer wants an IME. Am I allowed to have it recorded or a neutral third party present? They claim they are conducting one for my benefit. Well, it doesn't matter what they claim, doesn't matter what they want. You're not required to do an IME. As long as your doctor is clear about what you need, your employer doesn't have the right to demand an IME. They can ask and you can say, thanks, but no thanks. I wouldn't agree to it. You have your doctor who knows you best and knows you better than anyone. So if they have questions for your doctor, if they need some clarification, your doctor can provide that. So I would not agree to an IME. I would not agree to go be checked by someone that's paid by the company. Don't agree to that. Okay, so forget about recording it. You're not going to be able to record it. I would not agree to it and simply say, my doctor said what I needed. If you need more information, ask my doctor, but that's it. That's what I would do, Fortress Maximus. I don't know why you would want to agree to an IME. If they give you a hard time with that, if they threaten to let you go, you call me, and you call me right away, okay? Employmentlawyer.ca, you see that right below me, is the place to go. All right, next question from Jessica on YouTube. I got fired because I am not vaccinated. I got nothing, not getting eye. There was no option for me, like a test or nothing. They say get vaccinated or I'm terminated for cause. I'm not surprised that's what happened to you because thousands of people have been in that same situation across Canada over the past number of months. That's the bad news. The good news is we can get it resolved. Give me a call. All right. Let's connect. My team, we actually represent hundreds of people across Canada in exactly the same situation. We've been resolving the matter, getting them severance, helping them get EI as well. So there's no point getting upset. Let's just do something about it. Call me after this session or email me. Everything you need, Jessica, is at employmentlawyer.ca. My number is there, my email address, my whole team. So let's connect and let's get to work. All right. Next question is from Susan on Facebook. If your union chooses not to represent you in arbitration, maybe you can represent another lawyer if you cannot advise. So no, Susan, you're not understanding. The union is the only one allowed to represent you. You cannot hire a lawyer. Not me, not anyone. You're simply not legally allowed to hire a lawyer. It has to be the union. And if the union refuses, you don't have many options. The only option you may have is to file a complaint against the union at the labor board. That's the problem with being unionized. You give up your rights to pursue matters on your own. You give those rights to the union. So it's not that I don't advise unionized employees, it's that no lawyer can. It has to be the union. There's no other options. There's no exceptions. All right. Christine on YouTube. I am past the 2-year mark for long-term disability and I'm still receiving benefits. What does the insurance company need for the benefits to continue to be paid? Well, they need updates when they feel that they need them from your doctor as to your condition, how much you improved or have you not improved. So ultimately, they need to understand what your condition is. If they're satisfied that you're not able to work, they're going to continue paying you. That said, I've seen this thousands of times, literally thousands of times. They may cut you off even though your doctor supports you. Okay, they want to get you off their payroll. So you can't assume that they're going to do the right thing. You hope that they will, and I hope that they will. But if they don't, which happens very often, if they cut you off, even though you can't work, your doctor agrees that you can't work, you got to call me. We have a whole team dealing exclusively with these insurance issues with LTD insurance companies. We can get it resolved. We can get you compensation or get you back reinstated. Follow what the requests are. If they need more information from your doctor, make sure you're responsive. Never ignore them. If they ever cut you off or even threaten to cut you off, you call us. Okay, we have a whole team just for that. So thanks for that, Christine. And for Christine and anyone else, as I've said, to connect with me off air, off social media, off Facebook, YouTube, employmentlawyer.ca. Once you go there, you'll have the phone numbers, the email addresses. I give you that address because it's just easier than to rattle out a phone number. So check it out. JC says, I guess I meant, why wouldn't they only have to pay the lower amount? Because the law says they have to pay the higher amount. It's as simple as that. It's not an option, right? If it was an option, of course, they would just decide to pay the lower amount. But it's not an option, okay? The law says they have to pay the higher amount. The lower amount is only relevant to those employees that have limited their entitlements with an employment agreement. So that's why it's not an option. There's no choice here. They don't get to decide what they prefer. The law says they must pay the higher amount. All right, Julia on YouTube. Great question. I can see it already. Why do most employers quote 2 weeks per year? Is it possible for them to claim an exemption from full severance pay if they don't have a lot of staff? Absolutely not. That's a great question, Julia. So the size of the company, the number of employees is irrelevant to your full severance. Whether the company has 1 employee or 1,000 employees does not change your severance. Now, why would a company say 2 weeks per year? There's one of two reasons. Either they don't know any better, or second reason, they hope that you don't know any better and they hope to get away with it. And here's the sad thing. Most people don't know any better. 70-80% of people, when they're going to be offered the 2 weeks per year, are going to assume it's fine, and they're going to sign that paper thinking that's all they're owed, when in fact it could be owed 10 times that. So the company often counts on that. They figured if we let go 10 people and we offer bad severance to all 10 of them, 8 of them are going to accept it because they don't know any better. That's pretty good odds. Well, if you're watching, you know better, right? You now know that you're owed much more severance than that. So for JC, for Julia, here's how you find out right now how much severance you're owed, your full severance, not the 2 weeks per year, your full severance. All you do if you want to find out now how much severance you're owed, you see that address below me, is you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We have our severance calculator tool there, and you can use that to find in seconds how much you're owed. By the way, it's free. It's anonymous. You don't have to put in any information about your name, your address. You don't have to put in the company's name. You don't have to put in a credit card number. You don't have to put in your address, nothing. So you go to pocketemploymentlawyer.ca. You answer 3 questions about your age, the position you have, and the length of your employment, and it's going to tell you how many months of severance you are owed. Even if you haven't lost your job, but you're curious, maybe you're worried about losing your job and you want to be prepared, the very first place you go to when it comes to severance, pocketemploymentlawyer.ca, our severance calculator tool. First thing you'll see there, check it out. Over 2 million people have used it already, so definitely make sure you do that as well. Okay, next question today. Great questions, by the way, guys. Keep them coming. Next question from Vidrana on YouTube. Regarding severance pay, who needs to take the step, employer or employee? I'm not sure what you mean. Severance is paid if you're let go by your employer. So if your employer lets you go, they have to pay you proper severance. If they paid you proper severance, if they paid you what they owe you, there's no issue. If they have not paid you, then we need to make sure that they do. The vast majority, by the way, of what an employment lawyer like myself does is we help people in severance issues. We make sure that they get what they're owed. Because the vast majority, probably 9 out of 10 people, when they're let go, are offered a lot less than what they're legally owed. So your employer has to pay you that severance, Vidrana. If they don't, you call me. You go to employmentlawyer.ca. And of course, as I said, go to pocketemploymentlawyer.ca to find out how much severance you're owed. Great questions. For those joining us, welcome. My name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru, Tumarkin, LLP, and I'm answering your questions live. So, next question today comes from Julia. Julia asks, is there any sort of penalty for employers who repeatedly refuse to pay proper severance? It seems like they hold all the power. Well, they don't, because the law is all the power, right? The law says you have to pay that severance. And yes, for employers, that don't pay severance, there's going to be consequences, right? They're going to face legal action. They're going to have to pay your legal fees. And that's why employers don't want to do that. So once I get involved and I tell your employer, nice try, you offered 2 months severance, it should be 10 months, they'll pay it in the majority of cases because they know they don't have the option. But that doesn't mean that they're not going to try to get away with it. But once I get involved, they know they can't. They speak to their lawyer who says, yeah, you have to pay what you have to pay. So often these severance issues get resolved very, very quickly within a few weeks. Okay, that's why I want you to do the right thing. If you lose your job, you're staring at that severance letter, you're not sure what to make of it, you're not sure if it's right or not, well, you call me, okay? Or you go to pocketemploymentlawyer.ca, use the severance calculator, and we make sure you get what you're owed. The one thing to remember is if you sign on that dotted line, maybe you didn't know any better. Maybe you thought you felt the pressure. There was a deadline, so you felt like you had to sign. Once you sign, it's done. It's too late. And if you realize the next day that you were owed an extra year's pay, there's nothing that you can do about it. So please, please, please do the right thing, do the smart thing. If you are let go, let's talk about it. At a minimum, go to pocketemploymentlawyer.ca. Okay. Next question on Facebook from Pearl Moon. Guys, by the way, great questions. It doesn't matter if your employer was mandated to have a mandatory vaccine mandate. Vaccination cannot be made mandatory in Canada as per the Immunization Act. That's not correct. Next question from P4WZ on YouTube. If someone is on short-term and has full support of the doctor, and it's all in writing, and the insurance denies short-term payments, can you get involved then, or is it just for long-term? Yes, we can absolutely get involved with short-term disability. And usually if you don't qualify for short-term disability, you also won't qualify for long-term disability, so we need to deal with both. So absolutely. If your disability coverage gets denied, if your disability benefits, I should say, get denied, call me. Okay, we need to speak, we need to deal with it right away. Okay, so please give me a call in that situation. Of course, to get that information, to connect with me, I've said this before, but just in case you joined us, employmentlawyer.ca, again, employmentlawyer.ca, to connect with me, to have that private chat or that private email exchange. JC 2004 has a follow-up. It says, okay, so the lower amount is then a legal restriction, limiting the employer to not go below a certain amount in a contract. I think I got it now. That's exactly right. So you can't pay less than the minimum, but the minimum is only relevant if there's an employment contract that limits you. But beyond that, it's not relevant. So forget about people ask me, what is my minimum entitlements? I say, why do you care, right? Doesn't matter if your minimum entitlements are 3 weeks or 6 weeks, who cares? What matters is what you're actually owed, your full entitlements, your common law entitlements. That's the only thing that matters. The only time we'll ever care about your minimum entitlements is if you sign an employment agreement that limits you. And even then, by the way, if you did sign an employment agreement that limits you, in many cases, we can get around it for various reasons. Okay, so very important to keep that in mind. All right. Next question from Verdrana. In other words, if I'm not asking for severance pay, is my employer going to pay it to me? You're in a unionized workplace. Unionized employees don't really get severance, okay? Unionized employees can get their job back if your employer lets you go improperly, but again, the union has to help you. So that's, as I said, whatever we talk about today does not apply to unionized employees, okay? Only to non-union employees. All right, follow-up question from Fortress. Fortress Maximus on Facebook. Can an employer force you to undergo sensitivity training? Asking for a coworker. Well, depends on what it is that the employee did. In some situations, if the employee is found to have acted improperly, then an employer can say, well, we need to make sure that doesn't happen again, so we require sensitivity training. In other situations, if sensitivity training is done for everyone in the workplace to make sure that people know how to treat each other and behave, that's okay as well. But for the employer to pick on someone and say, you and only you have to undergo sensitivity training, there has to be a good reason. The employee would have had to do something wrong. And then, yeah, it would be appropriate. Okay. Next question, guys, from JC 2004. In the event a third party requires you to get a COVID test to enter a work site, what rights do you have to ensure that the test and the test results are not retained or shared by the third party? So listen, you can ask them what they're doing to ensure your privacy. They may not tell you, but keep in mind they're legally required to keep that information private. And if you find out they're not, there's legal consequences. As a practical matter, if it's a third party that you're not related to, and you say, tell me what you've done, or how you're going to store my materials, or how you're going to protect privacy, they may not tell you. They'll just say, that's our business. We abide by the law. So as a practical matter, you probably can't do much unless you find out that they've done something wrong. Okay, very important. Next question today from Rocket. Can an employee be liable for wrongful resignation if they don't give their employer enough notice? Potentially, yes. So first of all, resignation, you have to start by looking at an employment agreement. Your employment agreement may say how much notice you have to give your employer, 2 weeks, 3 weeks, and then you should abide by that. If you don't have anything in your employment agreement about that, then you have to give reasonable notice, whatever is reasonable depending on the type of job that you have. The reality is, if you don't give enough notice, it's going to be very, very difficult for your employer to pursue it. They'd have to show that because you didn't give enough notice, they incurred losses. It's going to be tough to do. Not impossible. So there is that risk there, right? But very, very, very difficult for your employer to do. I'll take one more question today, and that question comes to us on YouTube from Sonia. I was terminated without cause, but was given code M in the record of employment with comments in box 18 due to vaccination policy. My doctor lost her license and could not provide any further info. Why am I being denied? Well, you're being denied EI because of the record of employment, but you're also going to be denied severance. That's where we come in, okay? We have to get involved to help you get EI, to get you a new record of employment so you can qualify for EI, and of course, to get you severance as well. All right, so you have to call us, Sonia. I can't represent you. I can't actually do something for you here on social media. You need to contact me. So if you want to have a chat privately so I can get to work and help you, just go to employmentlawyer.ca. You see that address right there, employmentlawyer.ca. All right, great questions. Some of the best questions today, guys. I appreciate that. Thank you for your time. My name is Lior Samfiru. I'm the employment lawyer. I'm one of the partners at Samfiru Tumarkin LLP. You can reach out to me to have that private chat. As I said, I'll be back next week, but don't wait until then, okay? If you have legal issues that need to be dealt with, let's deal with them, okay? They shouldn't be sitting and waiting. So reach out. Otherwise, I will see you next week. Thank you so much for joining me. Hope you have a great rest of your day. Take care.